From the News Channel 5 Network, this is MorningLine.
Good morning, everyone. Nick Barris here. Thanks for joining us on MorningLine on this, a Monday. We have a good show on tap for you. In fact, it's a special edition of MorningLine in the sense that we are going to take this right up to the 9 o'clock hour as we normally do, and then we're going to segue into gavel-to-gavel coverage this morning of a hearing, I think a significant hearing, with what they'll be discussing today in the Vanderbilt rape case and what's going to happen next. We all know a trial is scheduled, the second trial on this for the two defendants for November 30th. A lot going on this morning, and we're going to talk about it today with News Channel 5 legal analyst Nick Leonardo, who will stay with us at least for a portion of this hearing this morning. And Nick, it's good to see you, my friend.
Good morning.
Thank you for coming in. It seems like, you know, it's been a while since we've done these legal issues. We thought when the first trial concluded, well, okay, that's over with. Boy, were we wrong.
That's exactly right. You know, I was. You had asked me earlier in the week. You know, did the motions that were going to be heard today seem somewhat unique? And you know, Nick, really, this entire case is becoming a very unique case.
No question about it. We all know that the convictions of Brandon Vanderbilt and Corey Beatty were, I don't know, thrown out because of juror misconduct. A new trial scheduled for November 30th, which we will be covering gavel to gavel here on the Plus if that happens. Now, what's significant about this today, Nick, is it's a hearing before Judge Monty Watkins. Several motions have been filed by the defense.
Correct.
You've had a chance to go over it. I want to kind of preview this, and we'll take calls from you, the viewer, on what you think about all this. I know many of you are frustrated by this legal process, but it is the process we all have to live by. You've looked at these. Is this a lot of motions in your opinion? And maybe walk us through a couple of them that caught your eye.
Well, there are actually, you know, some of them are the same motions for both of them. They're both trying to sever, you know, get separate trials from the other.
That's the big thing. They want to separate. They were tried together the first time. Why do they want to do that, Nick?
Well, you know, it depends on, you know, anytime you have a co-defendant, if you and I were going to trial, let's say, and there was some statement that you made that I was going to use saying that, you know, Nick Barris did it, well, you have the right to confront, you know, your accuser, but you also have to balance that right with the right against self-incrimination, because you may not want to testify. So depending on the statements, co-defendant statements that they want to use against the other one, you know, that would dictate whether or not their trials would be severed. And of course, the state could diffuse the whole situation by saying, we don't intend to use this particular statement, we don't intend to use that particular statement. So the severance motion is something I think the court's obviously going to take up today. And something else that I thought was rather interesting, they both at this time had filed motions for discovery. And one of them, one of the interesting issues is that typically they have what's called open file discovery. So when you go to the state and say, I want to know what evidence you got against my client, the state will say, well, here you go, here's our file, you can go through it and just take a look. You know, any of the stuff in this file is subject to being used. Well, now they've asked, no, we really want to know specifically what, you know, you're intending to use in this particular case, because we're entitled to that. And the interesting thing too is when you know, filing a motion for discovery is nothing more than asking the state to tip their hand, and they're required to do that to show the evidence they're going to use against the criminally accused at trial. But anytime a defense attorney does that, or the defendant does that, then they have to also show the state what they intend to use. So they waited here until the 11th hour to file this, I guess because they realized that they don't have anything necessarily that they want to keep from the state in their defense. If that makes any sense.
What could it be? And well, here's the thing too, for them to be asking this, I mean, we saw everything that the state has and everyone else did in the first trial.
Correct.
Is that assuming that could there possibly be new evidence that the state has uncovered since the last trial, which I seriously doubt, aside from maybe some of the statements maybe that Corey Beatty made to Dr. Phil or something like that?
Well, you know, that's a prime example. There is some new evidence. You know, is the state going to want to use any of the statements made by Corey Beatty on the Dr. Phil show? But part of that severance motion, and you have to read between the lines on these things, but part of the severance motion filed on Mr. Beatty's behalf also says that he would like to continue the trial date because he would like to conduct some independent testing or analysis on some of the evidence in this trial. So he's asking to do that as a basis for a continuance, and we'll see how the judge takes that.
I'm telling you, okay, look, and sometimes you'll lean on me, and you know, of course, you've worked on both sides of the aisle, but you're like, Nick, you sound a lot like a prosecutor is what you'll say to me. Now, I looked at some of these motions, and I know some of the viewers out there. Again, these gentlemen now, I don't use gentlemen, I take that back. These men are innocent till proven guilty right now, but you know, there's not a defendant in the world that doesn't like a delay, okay? We all know that. The more delays they can get. So Vandenberg, all of a sudden, his attorneys want to do some more testing that maybe wasn't done on this evidence the first time around. If I'm the judge, I'm like, dude, you've had time. Ain't gonna happen. Now, I'm guessing the judge is just looking at all of this as to whether or not he could come back up as a legitimate issue on appeal. Otherwise, I'm saying no. Why on earth would you grant him more time on this when he had plenty of time the first time around?
Well, and Nick, you got to be very, very careful here. This new lawyer, this Mr. Bolin, I don't think he's been on this case very long at all. Okay, and if you remember, Attorney Fletcher Long was previously on board, and so since he's had his own legal wranglings and he's no longer practicing law,
right?
This particular lawyer may not have had exactly enough time to get up to speed. Now, the advantage this lawyer does have is that we carried this trial gavel to gavel, and so he can go back and watch this trial and see how things unfolded.
But again, it seems like behind-the-scenes workings. Now, Fletcher Long, of course, is no longer practicing law. He was let go by Vandenberg after the trial before he lost his law license. John Herbison was in the mix. So they made that move on their own to say, look, we lost the first time around. I don't blame him. Let's try some new attorneys. That's their call, okay? They didn't have to do that. Now, they could have kept Herbison, or they could have kept, and they still have Albert Perez, who was on the legal team originally. So the judge is saying, look, you can just go ahead and willy-nilly get rid of your attorneys and buy yourself more time by saying I have these new attorneys that have to get up to speed? I don't see how that's fair.
Well, this case, is definitely unique, and there's been a slew of lawyers, and don't forget that, if you notice on the motions that were filed, Mr. McKenzie and Mr. Banks' lawyers also got copies of. So there's a lot of defense lawyers that are involved in this particular case, and you want to make sure that you do not leave any basis for appeal if these two individuals are convicted.
Right.
And so, I don't see the judge giving them 3 and 4 continuances, especially since they're involved with potential jurors out of Hamilton County down in Chattanooga. You don't want to waste their time either. Once we tell them they're coming in next week, we need to be there so that we can conduct these questions. And one of the motions that's actually been filed in this case is to have the jury complete a written questionnaire for jury selection.
And we're going to get into exactly why all that is and the jury selection, so we don't have the same debacle we had the first time. Real quickly, before we go to a break, and there's a lot to talk about, let's take a call from Joe. Joe, good morning.
Good morning, Nick.
Hey, Joe.
Nick.
Hey, good morning.
How much do you think this has cost the state of Tennessee to drag this thing out like it's going? And if I remember correctly, Vandenberg, back when Fletcher Long and Herbison and those guys were representing them, they was kind of complaining that they didn't have any money to continue on. They was running out of money. It's amazing to me that all of a sudden both of these guys, Beatty and Vandenberg, have come up with a bunch of lawyers, and I know these lawyers are not, I'm assuming that they're not working for nothing. So, it's kind of confusing to me that with all the motion that's been filed and the lawyers involved in this, it's costing a lot of money for the defendants. Plus, how much do you think this has cost the state of Tennessee to drag this thing out for 2 years?
What do you think about the cost?
There's no doubt it's it's an astronomical amount, but it's really going to go through the roof when they have to go to Chattanooga to get these jurors. If they do end up trying this case, and let's say that the judge does sever it. Okay?
Oh, I was going to say, add that to it. What if he severs it? Then that's one trial for each of them. And remember, there's 2 other defendants that I never believe are ever going to go to trial, but there are 2 others still waiting, possibly. Remember, there were 4 individuals originally charged in this rape, but first there's Vandenberg and Beatty. Can you imagine if there were 4 separate trials, the cost of that?
Well, those 2 other defendants have already been severed, so it's 2 and 2.
Right, that's true. That's
okay?
right. That's right.
And so, if you have to go out and get these jurors in Chattanooga, bring them here, feed them 3 meals a day, do their laundry and all that.
Put them up in a hotel.
Put them up in a hotel. This could be a multi-million-dollar case. It's probably getting pretty quick. It's getting there pretty quick as we go at this point. They had 3 weeks of trial the last time.
Yeah, count all that. That was expense out the window. And to this day, I still am not quite sure why no legal action has been taken against the juror responsible for the mistrial.
That's maybe there's still an investigation going on, but that's something that the District Attorney General,
I just don't think it's going to happen.
Decide.
And there may be questions about, and that's a whole separate issue. But this would not be happening if there wasn't some misconduct by that juror.
Well, maybe they ought to send him a bill.
Yeah, that's what I think they ought to do. All right, we'll take a break on that note. When we come back, we're going to get into some of the other things you were talking about, that juror questionnaire, the issue of severing and all of that. How this must play out, what the prosecution may be thinking about with regard, do they take into account what the alleged victim in this case wants or doesn't want. And what do you think? Is this a frustration for you? Will you be watching when we go gavel to gavel again? Will there be something new? I suspect a lot of people will be watching. We'll take a break and be back with more of your calls and more with Nick right after this.